Theft charges. How serious are theft charges? What can you do about it? Welcome to the Fulgham Law Firm and our YouTube channel. Today I want to talk about theft charges. What can you do to possibly dismiss them, and what type of defenses should you be looking at to preserve your freedom and your good, clean criminal record? By the way, if you wait around to the end of this video, I'll also give you a free ebook, What to Do If You've Been Charged with a Crime in Texas. Okay, so let's talk about theft. When you talk about theft, listen, technically it's one of the most common crimes that people commit in the state of Texas and pretty much anywhere else, any other state in our country. But one of the things that you have to be aware of, some people kind of take it for granted. They think it's not that big of a deal. Who cares if you're charged with theft? Even if it's a petty theft, it can have very serious long-term consequences to your future. Not only employment, but other prospects. So let's talk about that. Let's break that down. When you're going to begin to look at the crime of theft, the first thing you want to say is, let's determine how it's defined. What is theft? Theft essentially is the taking of any property, services, or pretty much anything of value with the intent to permanently deprive the owner of that property. So one of the things we find is if it's taken just because someone is in possession of stolen property is not the same thing as having committed theft. We find this happen many times where someone will actually maybe taking an item they did not know was stolen, but they were pawning it. Maybe they went to a pawn shop and they went to pawn it, and it triggers on the lead system out there. It's called the leader system out there that comes out. It says, hey, this is a stolen item. The pawn shop immediately contacts the police and says, hey, we got some stolen items right here. Guess who shows up at the pawn shop? The cops, right? And they arrest this individual for theft. It does not mean they committed theft, even though they may be in possession of stolen property. So let's talk for a few minutes. When you look at theft, it's kind of a broad category. It's kind of an umbrella of crimes that include everything from robbery to shoplifting to theft of services, theft of property, credit and debit card abuse, forgery. Usually some of these more serious theft type offenses add another element, like robbery is theft plus an assault, something along those lines. But let's just talk about possible ramifications when you talk about theft. The number one thing when you take a look at the crime of theft is value. What is the value of the item that is allegedly stolen? The more expensive it is, the more serious the crime. So the lowest of all theft charges is a Class C misdemeanor theft under $100. Now, what does that mean? Well, a Class C misdemeanor is a ticket punishable by a fine only of up to $500 and no jail time. It's tempting to look at that and say, well, who cares? It's not that big of a deal. Well, if you take a conviction to that, and what does that mean? If you go in and you pay that fine, you are now convicted. It will be on your permanent criminal record. And so it's a big deal. And we'll talk about why it's a big deal here in a few moments, but don't just pay the fine, okay? Now, what if it's $100 to $750 in value? Now you're looking at a Class B misdemeanor, punishable by up to 180 days in jail and up to a $2,000 fine. And then if you jump that up to $750 to $2,500, it's a Class A misdemeanor, punishable by up to a year in county jail and up to a $4,000 fine. And then you go above that. You go above $2,500, you start reaching up into the felony range. So it becomes a big deal because you don't want to put yourself in a place where now you become a convicted felon because of the value of an item is estimated to be over $2,500. So, and what I mean by that is the higher the level, that the so-called level of what the value of it is, the more you have to be concerned about what type of charge, whether it's a misdemeanor or felony theft that you're facing. Now, what are the long-term consequences for a theft conviction? We talked about this. Listen, the title of this video is How Serious Is It? Well, first of all, any theft charge is very, very serious, okay? Because if you take a theft conviction, whether it's a misdemeanor or a felony, it is known as a crime of moral turpitude. Now, what does that mean? It's a crime of dishonesty. So many people look at that and they see it as, quite frankly, you can't be trusted, okay? So that affects you with employers. It affects your ability to be able to get a job somewhere because many employers will see that theft conviction and say, no way, can't trust this person. We're going to cut them off. We're not going to allow them to have the job, okay? So it's critical, not just employers, but anything else out there. That's how people's impression will be of you. So you cannot take a theft conviction. It's critical. Now, what about what are some of your options? What if instead of a conviction, what if you take a deferred adjudication? Deferred adjudication is essentially a type of probation that if you complete the terms and conditions, your case is dismissed. And the only downside to deferred adjudication, you do not have the right to have it expunged from your record. Your theft technically would still be on your record, but it would be sealed. Now, the good news is your employer, any potential employer, would not be able to see it unless you were going to work for the government or there was a licensing board that was involved, like you want to be a lawyer or a doctor or something along those lines, okay? So that's one option, is deferred adjudication. Whatever you do, don't take a straight probation. A straight probation is where you're convicted and then placed on probation and you stay out of jail. But I want you to understand, this is why it's critical that you hire the right kind of lawyer. Many attorneys will not make the distinction between these two types of probation. If you take a straight probation on your theft case, it is forever on your record. So you do not want to take a straight probation. That's one of the worst options that you could consider particularly for a first-time theft case, okay? Now, let's say your case is dismissed. Sometimes you can get what's called a conditional dismissal, where you can negotiate, your attorney can negotiate with the prosecutor to have your case dismissed if you do a few things up front. Or maybe your case facts are terrible for the state and they can't prove it beyond a reasonable doubt. Either way, if your case is dismissed, your next thing you want is you want it to come off your record. So there's some rules related for that. Most people think that it's, number one, that maybe it automatically comes off your record. No way, nothing automatically comes off your record. Usually you're looking at a waiting period of about 2 years for a misdemeanor offense, and it can be 3 years for a felony offense, okay? So this is why it's important not just to hire a lawyer that can handle the theft case, but that also knows the rules to get this mess off your record, okay? It's kind of a two-pronged approach. You want to stay out of jail, you want to not be convicted, and you want this to be able to come off your record. Those are usually three of the big goals that everyone's looking for if they're facing a theft charge in Texas. So if your case has been dismissed, you need to then determine whether it's a 2-year, a 3-year waiting period to get it expunged from your record, and then you can begin to move forward. And when I say expunged, whether it's a non-disclosure or an expunction, your criminal attorney can make sure before you work out a plea deal of any sorts, you need to make sure what your goal is so that you can achieve that goal to get it off your record, all right? Now, quickly, what are some defenses? It's a couple of defenses. One of the best ones is value, okay? If someone claims that the item that was stolen was worth more than what it actually was, you've got a great defense to claim that they can't really prove value. So let's say they just have some handwritten receipts, or they didn't really do a real estimate, but they just guesstimated on their own because that's what they think it's worth. That is not proving the element of value. So let's say that the amount they claim is $3,000 in damages, but you're a criminal defense attorney who knows what they're doing, is able to get an estimate and work with you through a professional to determine the actual value is $2,000. Well, why that's important is that would now place that felony charge down to a misdemeanor charge. And if it's a felony, that could be presented to a grand jury, and you could end up having your felony drop to a lesser charge. And it's always easier to fight a misdemeanor than it is a felony. So that's one defense. Next, what if you did not have the intent to permanently deprive the owner of the property? In other words, what if you borrowed it? What if you have a history of borrowing property from this person? What if you've exchanged items and borrowed them in the past? And yes, you had it, but you intended to return it. That's a legal defense. Then, like I said before, if you just flat out didn't do it, what if someone else did it? These are all valid defenses that you need to make sure that you go through with your experienced theft attorney. And listen, if you are facing a theft charge in the North Texas area, don't hesitate to contact the Fulgham Law Firm at 817-877-3030. Listen, we'll give you a free consultation. We'll walk you through the entire process. You owe it to yourself to make sure you're protected. Don't risk your future by not making a good decision about how to defend your theft case now, all right? Thanks for joining us today. If you enjoyed what you heard today, like our video, subscribe to our YouTube channel. We'll send you more great content just like this. Thanks.